Hi, I'm Victor Martins from Martins Law. I'm a lawyer in Ontario and I exclusively practice in the areas of real estate and wills and estates law. Today I wanted to discuss the different ways that you can revoke your existing will in Ontario. It is relatively simple to revoke your will, but you want to make sure it is done right to avoid any future disputes amongst your loved ones. But first, what are the reasons why a person might want to revoke or cancel their existing will? This is usually when there has been a major life change, including things like divorce or separation, or someone named in your will dying before you. Maybe you acquire substantial assets like a home in another province or country, or maybe you lend money to a child and want this to be treated as part of their inheritance so that all of your children are treated equal. These are the kinds of life changes that may cause you to want to revoke your existing will. It is also important to point out that you can only revoke a will if you have sound mind and you have the required legal capacity. If you lose the legal capacity to make a new will, you also lose the ability to revoke an existing will, unless your capacity is regained. So, assuming you know you want to revoke your will and assuming you have the legal capacity to do so, there are three different ways to revoke your will in Ontario. The first way is to simply make a new valid will. By making a new will, all of your prior wills are automatically revoked. Although this is done automatically, it is still a good idea that your new will still say that all prior wills are revoked. So that is option number one, revoking your existing will by making a new will that is valid. Option number two, destroy your existing will. A will is one of the few legal documents that can be revoked by physically destroying the original copy by doing things like shredding it, tearing it, or burning it. However, the person destroying the will must either be the will maker themselves or a person that is with the will maker who is directed by them to destroy their will. So again, option number two for revoking an existing will is to destroy the original copy. The third and least common way to revoke a will is to sign a separate written document that revokes your will. However, for this option to work, the document must follow the same legal requirements that make a will valid in the first place. If you were to use this option, you will want to see a lawyer to ensure that the written document is itself written and signed in a valid way. Now that we have reviewed the three options, and again, those are number one, making a new will, two, destroying the original copy, or three, signing a valid document that revokes your will, I must say that the most common way to revoke your will is a combination of options one and two. Most people make a new will with their lawyer, and that new will usually states that it revokes all prior wills. In most cases, those same clients will then shred, tear, or otherwise destroy their previous will to prevent confusion. Really quickly, there used to be a fourth way to revoke your will in Ontario, and that was through marriage. However, as of January 1st, 2022, marriage no longer automatically revokes your will, as long as you get married after January 1st, 2022. If you have a will and got married prior to this date, please contact a lawyer to determine whether your will has been revoked by your marriage. So there you have it, the three ways and one former way to revoke your will in Ontario. If you have any questions, please feel free to comment down below. Don't forget to also like, share, and subscribe for more informative videos like this. Again, I'm Victor Martins from Martins Law. Thank you and have a great day.